And we need to figure out how that work is key to rebuilding and to building the right sorts of relationships, what role it can play. And then we need to imagine how in doing that work around social protection and incapacitating those who are either unwilling or unable to live in these different kinds of connections, that we do that in a way that doesn't preclude the possibility of them being able at some point to be involved in the work of justice, in building just relationships. And so I think we would imagine not that we would never need a criminal justice system, not that we would never need any of the tools that we currently have in our toolbox of criminal justice systems and penitentiaries, but we would think about them as having different purposes and different goals, and I think we would operate differently. In terms of where this has led me in other reflections is to think about if we actually did start to think about justice relationally, I think it would cause us to question some of the divisions and assumptions that underlie our legal system more generally. So at the moment, restorative justice advocates and those in the mainstream system, I think, see restorative justice as fitting quite neatly into the box of criminal justice and in the criminal realm as sort of the correlate to alternative dispute resolution in the civil realm. But I think if you actually see that what's going on in restorative justice is an attempt to think about justice relationally, is an attempt to start from this point of connection rather than separation, and that it views wrongdoing then as about harms to relationships, that has to force us to think about why we have these artificial divisions, these fictions of divides between private and public law, right? Between what's a crime and what's a tort. And most lawyers know this, right? You can file a crime, you can file a tort, a civil suit about things that you can also have criminal charges pending, and the line about when the public is actually interested in broad-based civil claims where we have class action suits, as opposed to criminal claims where we see there's a public interest, but we serve that in a different way through the involvement of the state. I mean, we know that these are, in some significant measure, fictions. But I think the starting point of thinking about law through this relational theory lens forces us to actually say, well, if they are fictions, then why aren't we thinking about what really matters is who's harmed, what's the scope of the harm? Because we probably know, if we take seriously our connectedness, that it's never going to just be a private harm between one individual and another. But that the web of relationship that's affected, or the ripple effects, how far the circles go out, may be smaller in some cases and broader in others. And what we ought to be caring about is creating processes that are able to invite those in who are relevant to addressing that harm, to moving forward in a just way, and to holding those who are responsible to account in a productive way and in a way that empowers them to participate in more meaningful relationships. And so if that's the case, then we start to think differently about wrongs. And that doesn't mean that we don't want to be clear about what we think is wrongful, right? As opposed to what's just generally dysfunctional or not as good a relationships as we wish we had with folks. I think a relational perspective shows us the significance of relationships for a range of social institutions and for our daily lives. But that doesn't mean that we don't then want to at least be quite clear and precise about what do we as a collective through the lawmaking process think we want to mark out as those things that are wrong because there are harms that warrant intervention and involvement and attention. But then once we've determined that, we need to have our response be one that can actually respond to the nature of those harms as relational harms and as involving more than just the two individuals. So I don't actually want to move away from the idea that justice issues are actually issues where there's a wrong at stake. I don't want the whole universe of issues to be justice issues. And I also think we can't have justice without law. But we would think about our justice processes and our lawmaking processes in a much more inclusive, participatory way, and both of them would start from the assumption of our connectedness to one another and what the project is about. And then we would see the implications of our relational nature as selves for other social institutions as well, without having to make them justice institutions. So this is a challenge to those, I think, who are trying to, they've glimpsed an insight through their work in restorative justice, and in order to see where that's relevant, they want to make everything about justice or restorative justice, that's the worldview. And I guess my work is increasingly forcing me to see that maybe the worldview is that we're relational beings, that we're relationally connected. And then, of course, we ought to make that matter, make that the starting assumption for all of our social and political institutions. And justice is central and very important to that. And so my little part of that thinking is, how ought this to affect our work in justice systems and in legal systems? And I'm hoping that others' work will be, how ought that to affect work in health and education and economic development. These ideas of relational theory and of our starting assumptions and our starting points are, I think, relevant to all of us, but particularly for those who are privileged enough to be in positions of power within the legal system. In part, it's a matter of changing the conversation, of changing the assumptions, of changing your perspective and the lens on which you look at things. And that's important because those within the system, new lens in hand, as Howard Zare would say, or with the ability to see how these assumptions are playing themselves out, actually can start to see where change is needed at an incremental stage, or where they can actually make a difference in their particular practice, or what innovative practices might be at their disposal, but they need some way to articulate why you would change it that way, or why you would do it that way. Or they come to a fork in the road where you can make choices in the way in which you develop the law, in the way in which you deal with a client, in the way in which you advocate for them, or in the way in which you bring arguments to the court. And you don't know which way to choose, and you choose by some value, right? Maybe the thing that orients you is efficiency or effectiveness or whether you'll win, and this might be another compass or another guide. It's also the case that lawyers, while they practice very often individually and with individual clients, have capacity to work together in their associations and their bar societies, and are very often participating in law reform efforts and turn to for advice and information. And I think that's a very powerful position that often, in the drudgery of trying to get their cases done, that we sometimes forget. And so I think that understanding that law can be a very powerful tool for changing itself is important. So, for example, judges, who I think we often think about as very powerful, and indeed they do have lots of power to shape and change the law, they rely on good counsel. They rely on counsel to come before them and make the sorts of arguments that will leave space for restorative principles in sentencing, or see how actually thinking about the goals of sentencing through this lens helps make sense of the choices that you should make, right? So they are the argument makers. They bring the fresh perspective, even if it's not successful initially, to the court, right? They are often leaders in their communities. They're often our community organizers in very significant ways. And that opportunity is open to lawyers more easily than lots of other professions. Armed with this sort of understanding of the system in which they're in, where they can understand more clearly the frustrations and the failures of that system, and maybe why it's failing us, why it is that we need the kinds of changes we need, not only within their individual legal practice, but within the communities in which they live. They're able to bring that knowledge of justice and of the legal system, of the way it works and the way it could be changed, to communities, to community activists, to folks who collectively can start to make a change, can start to make a difference, both within the system and advocating change from outside the system. I do think it matters, the perspective that we start from. I do think, in that sense, theory isn't always about just what all the old dead white guys said, that we need to reclaim the importance of theory, of concepts, and of thinking for how it is that we talk about what we do, how we articulate it to people, how we explain it, and how we're able to imagine what is possible for us to do. I tell my students regularly that if law was just a technocrat's sport, we wouldn't need all of these hoops for you to jump through to make sure that you are smart, able, reflective, lifelong learners. What we need are those who are able to think broadly and to place their individual work, which is important and key with individual clients, in a broader understanding of what's happening. And so I think we need to encourage students to see the importance of legal education as not only about how do you write a memo and how do you file a brief and what are the rules of civil procedure, but how are you going to understand the function of those things? How are you going to understand your role in society, your role in the legal system, and the legal system more broadly? Because otherwise they just become pawns in a big game that nobody controls anymore.